We'll be starting the next panel, and I'm pleased to be moderating this panel discussing global developments in animal personhood jurisprudence. My name is Christina Cladis, and I'm a staff attorney at the Animal Legal Defense Fund. I'll be moderating and speaking on this panel today. Before we get started, I would like to give a special thank you to our presenting sponsor, Carroll House Furniture, our platinum sponsor, the Brooks Institute of Animal Rights Law and Policy, and our gold sponsors, the Stray Dog Institute and Beyond Meat. The Animal Law Conference has been approved for 15 CLE credits, including 1 ethics credit by the California State Bar Association. Conference organizers will be in touch via email after the conference with information for attorneys to secure their credits. California attorneys, be sure to stop by the registration table during the conference this weekend to sign the California MCLE attendance record. This session will explore various efforts to enhance the legal status of animals, both through litigation and the development of laws all over the world, with varying degrees of success and with an explanation of why that is. And now I'd like to introduce my co-presenters. Hira Jaleel is a lawyer from Pakistan and is currently a teaching fellow and adjunct professor at the Center for Animal Law Studies at Lewis and Clark Law School, where she teaches food law and aquatic animal law. Prior to joining Lewis and Clark, Hira practiced law in Lahore, Pakistan, where she litigated extensively to protect the interests of non-human animals and helped draft animal welfare legislation at the federal and provincial levels. Diego Plaza is a Chilean animal rights advocate and nonprofit leader, founder of both the Center for Animal Law Studies, or CEDA Chile, and the Interspecies Justice Foundation. His career, which spans legal research and strategic litigation, has involved collaborations with various organizations worldwide. Currently, Diego holds several positions, including executive director at CEDA Chile, board member of the Interspecies Justice Foundation, regional director for Latin America and the Caribbean at the World Moot on International Law and Animal Rights, and CAL's ambassador for the Center for Animal Law Studies. And before I give my presentation, I'd like to give a very brief shout out to my colleague, Ari Flint. Ari was supposed to be on this panel, but this GIF, as far as I can tell, is basically a true-to-life reenactment of what happened to him. So unfortunately for Ari, he can't be here due to his self-inflicted soccer injuries. But luckily for you all, I'm here instead. But best wishes for a speedy recovery to Ari. And also, the views in this panel are my own, so don't hold anything I say against the people that pay my salary. So to begin, what is personhood? I think it's important to clarify what it is we're talking about. So what does personhood even mean? In my view, personhood is reflected in 2 buckets of rights that we have as persons. The first are substantive rights, and it's basically our right not to be mistreated. So when it comes to animals, litigation to expand their substantive personhood focuses on the creation of new rights for those animals, like the right not to be exploited for entertainment. The second bucket of rights that we have as people can be called procedural rights, and they allow us to defend ourselves when our substantive rights are violated, such as by filing lawsuits. So they help us enforce our existing substantive rights. So I think everyone knows why substantive personhood is important for animals, but I want to explain why procedural personhood is also crucial. When it comes to animals, the few substantive protections society gives them are provided in the form of animal cruelty laws. But because these usually take the form of criminal laws, they can generally only be enforced by prosecutors. And unfortunately, of course, prosecutors have their own priorities. Sometimes they don't have the staff, resources, or the interest to protect animals from cruelty. And I think that's especially true when cruelty occurs in places like factory farms that, could be important to a prosecutor's local economy. So what's the alternative? When someone hurts us as people, we don't only have to rely on the option of prosecutors intervening to protect our rights. We can file a civil lawsuit and ask a court to put a stop to harmful behaviors. I think animals should have the ability to do the same. The reason why that's so important in the United States is that to file a lawsuit, you need to have standing. And I'm sure I'm preaching to the choir here when I talk about standing, but you can have standing if you yourself are the one who suffers an injury from the conduct you're trying to stop or prevent. In animal cruelty cases, it is the animal who is injured. So if animals don't have the ability to be a plaintiff, then private lawsuits to prevent cruelty can only go forward if the lawsuits are brought in the name of a human who coincidentally suffered an injury from the cruelty to that animal. And of course, that doesn't always happen. It's actually rare. So when no human has suffered a coincidental injury, and when government law enforcement agencies refuse to take action, as they often do, animals are left to experience ongoing cruelty without legal recourse. So I want to show you a couple of examples, but fair warning, there are some disturbing images in the next few slides. The images you see here are from a roadside zoo in Wisconsin. The picture on the left is from a barn that caught fire, killing more than 30 exotic wild animals who were stuck inside. And when police showed up to investigate the fire, they went inside some of the adjoining buildings to see if those buildings had been affected as well. And when they went inside, they found dozens of additional animals who had died. Not from the fire though, but from being neglected for months. That's the image you see on the right. We obtained these images from body cam footage of the police investigation that day. And in the footage, you can see the zookeeper admitting that she hadn't checked on the animals for, and I quote, a few months during the winter. And again, this was in Wisconsin. So these images went sort of viral, and nearly 8,000 people signed a petition asking the prosecutor to press charges. But despite all of this evidence, the prosecutor never took action. So the Animal Legal Defense Fund filed a lawsuit. And this is one of those rare cases where I mentioned where animal neglect can result in a coincidental injury to a human. Because of course, as I'm sure people here know, the Supreme Court has said that people have an interest in viewing animals free from harm. And so we argued that one of the Animal Legal Defense Fund's members visited the zoo, developed connections with those animals, and then suffered aesthetic injury as a result of the animal's mistreatment. And we were successful. And so this video that I would like to play is what's possible when we have standing to protect animals. It's very fun to watch that video, I think. It's nice to see that zoo being torn down. Okay, but sometimes we're not so lucky like we were in that situation. And so the images you see here are from a dairy farm where we came across some awful cruelty, and not just the type of mistreatment that's industry standard, but things that even the industry acknowledges are inappropriate. And as you can see from the picture on the left, the facility would use a tractor to pick up injured cows that could no longer move. They would drag them across a wall or floor and dump them aside with any food, water, veterinary care until they slowly died. The picture you see on the right is from an industry guide showing that facilities should not pick up cows this way. Despite this evidence of textbook cruelty, prosecutors did not take any action. The Animal Legal Defense Fund tried to file a lawsuit about this, but was unsuccessful. Because unlike a roadside zoo, a dairy farm isn't open to the public, and people won't be able to visit or have the ability to develop an aesthetic connection to the animals. And cows are also not protected by laws like the Endangered Species Act that have citizen suit protections. So when prosecutors ignore the problem and there is no human withstanding, illegal animal cruelty may be allowed to continue unabated. And cows like this, who struggle to stand many times before dying, and who suffered from starvation, dehydration, and injury, are left without any recourse. And this is why personhood is so important, because animals have interests of their own and should be able to protect themselves. There have been different approaches to personhood litigation. Some groups, like the Non-Human Rights Project, have focused on substantive personhood, where they try to create new rights for animals, like the right not to be exploited by zoos. And though they have not yet been successful, they have attracted inspiring dissents, like in their case on behalf of Happy the elephant, where Judge Wilson wrote that we should recognize Happy's right to petition for her liberty because the rights we confer on others define who we are as a society. At the Animal Legal Defense Fund, we have focused our efforts on procedural personhood, where we try to persuade courts that animals should be allowed to enforce their existing rights. And we've had mixed success. Our case on behalf of Justice the Horse, where we argued that a horse should be allowed to sue the owner who abused him, was not successful. But our case on behalf of a group of Colombian hippos who were plaintiffs in a Colombian suit and needed to obtain evidence in the US was successful. And the reason our hippo case was successful, I think, is because it funneled the animal personhood question through a foreign source of law that already gave hippos the ability to enforce their rights. And then it funneled the question again through established US Supreme Court precedent, saying that any party to a foreign case, in this case hippos, qualify as, I quote, a legal person. This strategy, funneling the personhood question through binding precedent and through other sources of law, has the potential to be the future of personhood litigation. Because even if the court is just applying a rule created in another jurisdiction, it is also recognizing that animals can have standing and that animals can be legal persons. And I think that's powerful precedent. But we don't need to look abroad to continue replicating this result, because there are already dozens of local laws that we can explore here in the US. The rights of nature movement has swept across the US, giving us more than 36 local laws that grant some form of personhood to nature. And about, I think, 14 of those specifically include animals. These are two good examples, I think. Mendocino County in California and Licking Township in Pennsylvania both passed laws protecting ecosystems and natural communities, which include fauna and wildlife. And both laws allow residents to file lawsuits on behalf of those animals. This is what procedural personhood looks like. But there are a number of challenges to actually prevailing in these types of lawsuits. And one of them is that even if the law's procedural personhood is good, the substantive protections are not. Most rights of nature laws in the US only protect nature's right to exist, flourish, and naturally evolve. But it's hard to understand what that actually means. So when the residents of Toledo, Ohio tried to give Lake Erie the right to exist, flourish, and naturally evolve, corporations sued, arguing that the law should be invalidated because it is unconstitutionally vague. And the court agreed, saying that even though the law sounds good, it's impossible to understand what it actually means. Most rights of nature laws are equally as vague, but they remain on the books because they haven't been challenged in court yet. Any attempt to use them, though, would likely risk this type of result. There's a new law that gives fairly specific substantive rights to animals, and that's the law that the Non-Human Rights Project helped pass in Ojai, California a few weeks ago. The law recognizes elephants' bodily liberty, which I think is great, but it only allows the city, not the animal or any citizen, to enforce the law. So it's not the perfect marriage of substantive and procedural personhood that we're looking for. Even if a law does have a perfect blend of substantive and procedural personhood, there's no guarantee that litigation would be successful. That's because there's an underlying question about whether cities have the authority to create a new cause of action on behalf of animals. In our system of government, only federal and state governments have inherent authority. Cities have none. Cities are created by states, and they can exert only such powers as are granted to them by the state. So if a state doesn't say that a city can create a new cause of action, then a city's law can be invalidated on that basis. You can see that principle reflected here in the Louisiana Constitution, which quite literally has the point right there. Unless the Louisiana legislature says otherwise, Louisiana towns cannot create causes of action that govern private or civil relationships. Grant Township, Pennsylvania learned this lesson the hard way when it tried to pass a rights of nature law that protects water by banning fracking in their community. As a second-class township, it did not have the authority to create a new cause of action, as well as one that conflicts with state law. So unfortunately, the Western District of Pennsylvania invalidated Grant Township's rights of nature law on those grounds. What's great, I think, though, is that a lot of states have decided that they want their cities to have a larger say in how their communities are governed. So there are about 9 states where cities probably do have the authority to create a cause of action. That includes California, and about 24 other states where the legal issue is at the very least ambiguous and hasn't really been definitively decided. But we're not done. There's also the issue of preemption. Cities and counties have less authority than states and can't create conflicting laws. For an example, when Mora County, New Mexico tried to protect nature by banning oil and gas extraction in their community, the federal court ruled that the law was preempted since it tried to prohibit something that New Mexico state law permits. So there are a lot of legal issues at play, but we are digging into the full map of rights of nature laws, exploring their viability in each of the states. And I'm optimistic that one day soon we'll find a law that pairs specific, non-preempted substantive rights with the procedural personhood rights necessary to enforce them. And when we do, we'll be able to protect animals in those states, create precedent that animals are legal persons who can have standing, and then work towards spreading that precedent throughout the country. Thank you.
Okay, so hello everyone. I'm really happy to be here. So today we will be talking about some emerging jurisprudence in Latin America. Basically, we will delve today into 4 seminal judicial rulings from 2022 and 2023 in the southern cone of South America, specifically in Argentina and Chile, spotlighting pivotal discussions concerning the legal personhood of non-human animals. So basically, we will talk about 2 habeas corpus cases with different outcomes, and we will talk about also 2 criminal case law where the courts actually recognize animals as legal persons. If we have enough time, maybe we will be able to talk also about 2 multi-species families case law where the courts basically recognize animals as members of a family composed from members from different species. So without further introduction, let's start with the first one. So the first one is the case of Tori that was decided in Argentina in 2023, a brand new case, where an Argentinian court ruled that Tori, a chimpanzee living in captivity in a private zoo, must be sent to a great ape sanctuary. So it was like a pretty nice outcome for Tori, right? But the truth is that this case has been criticized by some scholars because of the reasoning that the court used in order to arrive to this decision. So, who Tori is? Tori is a chimpanzee, is one of the 3 chimpanzees still living in captivity in Argentina. He was born in captivity. He was transferred to different zoos in Argentina until his arrival to the private zoo of Bubalcó in Rio Negro. Since 2003, several formal requests has been filed in order to free Tori from his enclosure, including 3 habeas corpus cases with no success. But in 2020, a famous Argentinian nonprofit organization filed a new habeas corpus case on behalf of Tori, a habeas corpus that was decided as a constitutional protection action. This is as a different action because according to a court, the habeas corpus secures ambulatory freedom, but in this case, the truth, it was that other different rights were violated. So basically, on February 1st in 2023, the Judge Angela Sosa ruled or partially granted the protection filed on behalf of Tori, ordering his transfer to a grave sanctuary or center. So this case has been criticized for 2 reasons. First, the court abstained from declaring Tori's legal status. According to the judge, she would not pronounce on the legal nature of animals, but would instead address chimpanzees' rights. However, in the end, the rights discussion was subsumed within an environmental rights framework that led the ruler to conclude that the chimpanzees are in danger of extinction. Therefore, Tori as a chimpanzee should be protected and should be sent to a grave ape sanctuary. But in the end, basically the court grounded this decision on the violation of the constitutional human right to a healthy environment. So the defendants filed an appeal before the Supreme Court of the region. And in May 2023, the court denied the appeal, upholding the decision of the lower court. So with this, basically, the court upheld the decision of non-ruling on Tori's legal status and on grounding this decision on the violation of the constitutional human right to a healthy environment, but also it acknowledged that Tori was suffering, which became as an additional argument for his transfer. However, in his dissenting opinion, one of the judges explicitly stated that animals are not subject of rights, emphasizing that the civil code of the region classifies them as things and that they are already safeguarded by criminal and environmental laws. So we can criticize this decision from many points of view, maybe from using the same critiques that we cast regarding the first decision, but also we can criticize the dissenting opinion because the animal issue is not a private matter, so the civil code should not be a standard on which to base these cases. However, it has also been said that this second decision contained sound arguments to harmonize the property right defended by the zoo with the collective rights and with the norms that prohibit the abuse of rights. So, in conclusion, although these arguments are not the best, at least Tori's transfer was granted and his suffering was recognized. However, unfortunately, the zoo filed an extraordinary appeal before the nation's Supreme Court, so this endangers the fate of the chimpanzee, but at least I think that the Supreme Court of Argentina will have the chance to rule on Tori's legal status and to maybe ground its decision on the violation of Tori's rights. So we'll see what will happen in this case, but the truth is, according to some scholars, this decision may be one of the weakest in the new animal rights case law in South America. So well, moving forward to our next case, we'll talk about the Sandai case that was ruled in Chile in 2022. Basically, in this case, the Chilean Supreme Court declined to rule the first habeas corpus filed on behalf of a non-human animal in the country, asserting that only humans qualify as persons. Yet, within the same decision, it acknowledged that Sandai was deprived of freedom and ordered measures resembling habeas corpus, intended to safeguard the animal from adverse impacts related to his detention. So well, the facts are a little bit similar because Sandai was also born in captivity. Sandai was born in Germany, was transferred to France, then again back to Germany. And at some point in 2014, he was transferred to Santiago de Chile, to the Wing Zoo where he actually lives in. So since 2014, several NGOs and several activists have tried to liberate Sandai from his enclosure with no success. And in 2022, the Interspecies Justice Foundation, this is the NGO I proudly founded, filed the first habeas corpus on behalf of Sandai, asking the court to recognize Sandai as a non-human person, asking to grant some basic rights to Sandai, and also asking to order his transfer to a great ape sanctuary in Brazil. So this case was important because it was the first one in Chile. It introduces the Chile to this sort of regional trend of filing habeas corpus cases on behalf of non-human animals with different outcomes, and also was supported by 21 personalities from the animal law movement. Within them, for example, we can name Peter Singer, Gary Comstock, Adam Lerner, Caroline Rigat, and Cedric Riot, Zaffaroni, Liberatori, Liv Cox, Mark Pegov, among others. So basically, the case faced an initial rejection by the lower court. This is by the Court of Appeals of San Miguel. It was declared inadmissible. It was rejected in this sort of pretrial stage based on the absence of a violation of a constitutional warranty that could be protected by this means. So we filed an appeal, and in August 2022, the Supreme Court of Chile upheld the decision of the lower court, confirming the decision of declaring this habeas corpus inadmissible in a resolution that can be divided in two parts. So the first one, the Supreme Court stated that, okay, the Chilean Constitution grants basic rights to persons. According to a Spanish dictionary, persons are humans. Sandai is not a human, therefore Sandai is not a person and could not be protected through the habeas corpus. But in the second part of this decision, the court ordered the SAC, this is the Livestock and Agriculture Service of Chile, to adopt all appropriate measures to safeguard compliance by the Wing Zoo with the legal regulations regarding Sandai, specifically that the deprivation of his freedom does not cause him suffering and alteration of his normal development, verifying that there are adequate facilities for his species, avoiding all mistreatment and deterioration of his health. So we can criticize this decision from many points of view. First, we can criticize the limited lexicographic definition that the court used in order to define what a person is. He basically used the official Spanish dictionary, leaving behind centuries of evolution and discussion about what a person is. We can also observe this sort of intrinsic contradiction because despite denying the categorization of person for Sandai, the court also acknowledged that that he was deprived of freedom, a recognition that is typically reserved for individuals, not for things. We can also observe some habeas corpus implications because the court ordered the SAG to protect Sandai's interest during his freedom deprivation, suggesting the implicit recognition of certain rights, aligning with habeas corpus effects. We have to remember that the habeas corpus is not only used in order to achieve the liberty or to pursue the liberty of people that are unfairly imprisoned, but also to protect some other rights different from liberty that can be affected within the freedom deprivation. So we can see some sort of habeas corpus implications, which was a little bit strange. So this case have been studied by some scholars in Chile, such as, for example, Daniel Mondaca, who is a famous constitutionalist scholar in my country, and he made the same observations regarding this decision. First, he stated that we can observe some epistemic limitations in this decision because the decision unveils the court constraints in addressing and directly acknowledging Sandai's status and rights, resorting to generic formulas to prevent suffering and mistreatment. We can also observe a protection of unnamed rights or rights that do not have a name, because in this regard, the court structured a resolution scheme that simultaneously allowed to sidestep an in-depth discussion on the evolving nature of fundamental rights of ownership, while also affording protection to unnamed rights within the customary context of arbitrary freedom deprivation. And in conclusion, it has also been stated that in the end, the Supreme Court of Chile granted a deconstitutionalized constitutional protection. This is the court recognized that some interests that were not recognized as rights in the Constitution of Sunday were being affected and granted some sort of protection, but without using concepts of constitutional law or constitutional doctrine. So basically, maybe it wasn't the exact decision that we were expecting for, but at least we have observed some sort of transformation in the way that legal personhood is being actually studied in Chile. Students, while pursuing their JDs or LLMs or PhDs in law, basically, when they have to study this matter, they usually study this case as a sort of avant-garde perspective regarding the legal personhood. And well, it will be interesting to see how the Supreme Court of Chile will keep ruling these cases, because if the next time the Supreme Court grants a sort of protective measures for other animal interests, maybe at some point we could start talking about a sort of de facto animal habeas corpus in the Constitution. This is a habeas corpus that it doesn't actually exist, but according to the Supreme Court jurisprudence, the Supreme Court may find some sort of way to grant some sort of protections. Okay, so moving forward to more happy news, we will talk about the Dutch Hounds case in 2022 that was ruled in Argentina. So basically, in 2022, a Buenos Aires court ruled that 55 dogs were subject of rights, something that took place within the criminal procedure of an animal cruelty case related to 55 Dutch Hounds that were raised in an illegal puppy mill. So this case is really interesting because this declaration of legal personhood, it wasn't achieved because an animal NGO filed a request or an animal advocate. It was the prosecutor in this case who asked the court to recognize these dogs as subject of rights and to grant their total freedom and definitive custody. So basically, regarding the recognition of animals as subject of rights, the court followed the following reasoning. So on the one hand, the court stated that the recognition of sentient beings as subject of rights is not explicitly established at the local level in Buenos Aires. On the other hand, it stated that the protection of environmental rights, including the right to a healthy environment, this is the same right that was used in Tori's decision, is constitutionally rooted both at a regional and local level. It also stated that different international regulations and declarations recognizing animals as sentient beings and subject of rights actually exist. So it quoted the Universal Declaration of Animal Rights and also the Cambridge Declaration on Animal Consciousness. And in the end, after this three-step reasoning, the court stated that the legislative intent in Buenos Aires was to recognize animals as subject of rights. And in the end, it declared these 55 Dutch Hounds as legal persons, as well as those puppies that were born after the raid. And it related the quality of legal personhood with sentience. It was also interesting what happened with the request filed by the prosecutor related to the granting of the liberty of these animals, because according to a court, there is no legal measure or restriction conditioning their freedom, so the request related to ordering their total freedom does not warrant any consideration. So we can say a few things regarding this decision. Basically, it has been criticized because the legal argumentation in these cases must be as strong as possible, but in this case, unfortunately, the judge rationales could have been better supported by case law and also by bibliography on animal rights and legal personhood. It has also been said by some scholars, such as Silvina Peseta from Argentina, that appealing to a non-existent declaration is highly problematic. This is regarding the Universal Declaration on Animal Rights, which is not binding for states. And the same regarding the Cambridge Declaration on Animal Consciousness, which should not be quoted as the only or definitive scientific source on animal consciousness. It may also be a little bit problematic that the court related the quality of subject of rights with sentience. So this may give rise to a nuanced form of discrimination termed sentientism, which is arguably more intricate and refined than speciesism. Basically, sentientism restricts moral and ethical consideration exclusively to beings possessing sentience, thereby excluding individuals devoid of this characteristic, a factor inherently independent from their control or choice. But we can say like many good things about this case too, because the filing of the request by the prosecutor's office paves a new pathway towards recognizing the legal personhood of animals. This decision also took for granted that animals has the rights to freedom. Remember that the prosecutor asked the court to liberate animals, but the court stated, okay, I have not ordered any measure to restrict their liberty, so I won't rule on that request. And finally, it is interesting because it not only declared the 55 dogs as legal persons, but also those puppies that were not born yet at the moment of the rescue. So this case is another good example on how important it is to train not only judges, not only advocates, but also prosecutors, because if we train them, we may be able to achieve the recognition of legal personhood of animals by this sort of unconventional paths. And okay, let's talk about our last case today. We'll talk about the case of Mateo that was ruled in Argentina too in 2023. So this is another positive development for animals because basically a juez from Paraná, Argentina ruled that a dog could be represented in a criminal proceeding by an NGO specializing in animal rights. This decision acknowledged that the dog was a subject of rights, necessitating third-party representation in court because it couldn't represent himself in front of the court. So in order to understand this case, we have to understand the concept of querellante or querella under the Argentinian legislation. So basically, in the Argentinian criminal process, the querellante is a figure with a particular and specific role. It is the physical or legal person who, being a victim or affected by a crime, decides to actively participate in the criminal process to seek application of criminal law to whoever is responsible for the criminal act that affected him. Or in other words, the querellante is the one who files a querella or criminal complaint seeking the investigation and punishment of the crime that harmed them in some sort of way. So it may be a little bit difficult to translate this concept, but for now, only for now, we will talk about the private prosecutor as the querellante. So basically, a Labrador named Mateo, that was a stray dog, didn't have a multi-species family, was a victim of an animal abuse situation. In response to this, an animal nonprofit approached to a court invoking the quality of a private prosecutor while representing Mateo as a victim. So the thesis under this petition was that Mateo was obviously a subject of rights, that was actually the victim of that crime, and that could act in the criminal process as a private prosecutor. So the NGO invoked that quality on behalf of Mateo. So we have to remember that this process was just starting. So in a really brief decision, the court admitted the intervention of the animal NGO as a private prosecutor representing Mateo in his capacity as a victim and subject of rights based in the following reasoning. So first, the court recognized that both national and local jurisprudence affirm that non-human entities, this is animals, as bearers of rights. It also stated that according to the Criminal Procedure Code in Argentina, any person particularly offended by a crime can constitute themselves as a private prosecutor or querellante. And it also stated that animals are actually the direct victims in cruelty cases that needed third-party representations in order to act before a court. And finally, the court also rejected the argument against recognizing animals' rights based on their inability to demand them, pointed out that many humans also lack the capacity of language, yet are not denied rights. So in the end, the court acknowledged that Mateo was a subject of rights, quoting local and national jurisprudence, and also recognized their incapacity to represent themselves, necessitating advocacy, a role that could be actually fulfilled by an animal NGO. So I wish I could have enough time to talk about a couple of cases regarding the multi-species family. I know that Hira has to talk right now. So if you're interested in talking about these interesting cases, I will be more than happy to do it so after this presentation. I just want to say that in conclusion, we have observed through these cases that traditional roots such as habeas corpus and perspectives based on environmental law do not always align effectively with the affirmation of animals' legal personhood. However, it is heartening to see that both prosecution bodies and criminal courts are showing a nuanced approach to acknowledging and navigating the ethical and legal dimensions of animal rights and welfare. So it's really important to train advocates, to train judges, to train prosecutors, to train non-profit organizations, because we will be able to explore new paths different for the classic habeas corpus or the classic constitutional protection action that may lead us to obtain the recognition of animals as legal persons. So basically, the future is ours. Thank you so much.
Good afternoon, everyone. I'm going to be covering developments in South Asia, namely in Pakistan and India, and just a little bit of an overview of the cases that I'm going to be discussing. So South Asia, I think, is a jurisdiction where, or South Asia is a region where there's actually been a lot of animal protection cases and case law and jurisprudence. However, because I don't have enough time to get into every single case, I'm going to be talking about 3 cases from Pakistan and 3 cases from India to just kind of map out the trajectory of rights and personhood cases in the region. And in Pakistan, I'm going to start off by talking about the Kavan case, which was the first case in Pakistan that affirmed legal rights for non-human animals. I'm then going to talk about 2 cases that have then relied on the Kavan case to firstly affirm legal rights in other courts in Pakistan, and then in also a case that potentially could decide the question of animal legal personhood in the country. And in India, I'm going to be doing some context setting by talking about the 2014 case in Animal Welfare Board versus Nagraja, which affirmed legal rights for non-human animals, 2 high court decisions in India that actually affirmed personhood for the entire animal kingdom, and then the latest decision of the Indian Supreme Court in Animal Welfare Board of India versus Union of India, where the Supreme Court of India basically affirmatively disclosed its mind about what it thinks on the question of personhood. So just a little bit of a background first about the constitutional and judicial structure of these 2 countries. Both of them have federalist systems in that the legislative and executive power are divided between the federation and the states. In Pakistan, it's the federal government and provincial governments. In India, it's the central governments and state governments. The judiciary in both countries is a unified judiciary in that the Supreme Court is the highest court of the land, and anything the Supreme Court says is binding on all other courts in the country. And so starting off with Pakistan, the Kavan decision is actually a case called Islamabad Wildlife Management Board versus the Metropolitan Corporation of Islamabad, which is a bit of a mouthful. So I call it the Kavan case. This is a petition that challenged the treatment of animals in Pakistan's, in Islamabad's zoo, the Murghzar Zoo. One of the animals in question was an Asian elephant called Kavan. At the time, he was termed as the world's loneliest elephant because his partner had passed away a while ago and he was being kept in pretty horrific conditions in the zoo. And like I said, this is the first court decision in Pakistan that linked the constitutional rights of human beings to the legal rights of non-human animals. This is a picture of Kavan and Sher, who took a lot of interest in Kavan's plight and visited Pakistan to see Kavan. So basically, in this judgment, the court starts off by discussing the ways in which animals are being treated at the zoo, the way they're kept, the way they're neglected, and then talks about what legal protections the law in Pakistan affords these animals under the anti-cruelty regime. The court also examines case law from all over the world, including cases of Sandra, Sicilia, Arturo in Argentina, the Nagraja case, which I'm going to be talking about, and the Non-Human Rights Project cases in the US, and eventually concludes that non-human animals have certain natural rights by virtue of being living beings. And those rights are translated or protected by law, by the anti-cruelty laws. And so those natural rights are enshrined through the anti-cruelty legal statutory regime into legal rights. And when those rights are violated, that's when human beings' rights under Article 9 of Pakistan's constitution, which is the right to life, is also violated. So the court isn't saying that, or didn't say in this case, that animals have the right to life, in that the constitutional right to life extends to animals, but did say that they have legal rights. And when those rights are violated, because human beings' right to life depends on animals, because we are interdependent on nature, because of the link between human violence and animal violence, so when that happens, human beings' rights are also violated. And what do these legal rights for animals look like? Well, for the court, they look like the right to live in an environment that meets the animal's needs, the right to not be subjected to unnecessary pain and suffering, which is language that the law employs, the right to not be unnecessarily killed, and a right to dignity, actually, so the right to be respected. And because the zoo was clearly not meeting its inhabitants' social and physiological needs and was violating a lot of these rights that the court identified that animals have under the statutory regime, the court ordered that the zoo needs to be shut down and all animals within the zoo need to be relocated to sanctuaries. Subsequently, all animals, including Kavan, were relocated to sanctuaries, both within and outside Pakistan. Kavan specifically was relocated to an elephant sanctuary in Cambodia, where he's currently happily living. And so, before I move on to other cases that relied on Kavan, I do want to spend a minute talking about the additional note the court issued in this case, which was 3 months after the main judgment came out. So the context and the background to this is that the Prime Minister of Pakistan, after this judgment came out, said that obviously the federal government is going to honor what the court has said, and we're going to ensure that zoos in Pakistan are more animal friendly. And so the court issued this additional note to emphasize that that's not what the court was trying to say. So the court was not trying to say that make your zoos more animal friendly. What the judgment essentially was getting at was that zoos inherently cannot meet the needs of animals the way their natural habitats can. And so the idea is, when you're considering how to use an animal, such as in this case, keeping a wild animal in captivity, you have to center the interests of the animal themselves and see whether the use is justified considering the rights and the legal rights that animals have. So for example, if you're keeping an animal in captivity for conservation or to protect the animals, such as keeping them in a shelter or in a sanctuary, that use is justified, but keeping them confined because of it's educational for human beings or because of entertainment is just not a justified reason to infringe those rights that the law affords these animals. And specifically, the court said that wild animals have to be treated as an end in themselves and not as a means for the mere entertainment of human beings. And so what impact did this case have on other cases in Pakistan? What did it do for other animals in Pakistan? So there was a lot of litigation. This is a 2020 case, so it's not that old, but there was a lot of litigation in Pakistan since this case. And I'm only going to be talking about 2 cases, but there have been other positive developments as well. Both of these cases that I'm talking about now are from the Lahore High Court, which is a sister court of the Islamabad High Court. So Islamabad High Court precedent is not controlling in Lahore, but we see that the court independently adopted the reasoning that Kavan puts forward. So in this case, Zawar Hussain versus the province of Punjab, the Punjab Wildlife Department, which is a provincial wildlife department, issued a notification banning the use of electronic decoys and certain types of air guns in hunting. The text of the law already banned the use of live decoys in hunting. This simply extended that to include electronic, or interpreted that provision to include electronic decoys. The petitioner, who was a hunter, challenged the ban before the High Court on the grounds that, well, firstly, a strictly textual interpretation of the law means only live decoys are prohibited, not electronic. And also the petitioner claimed it's impossible to hunt waterfowl in the province without decoys. And in upholding the ban, the Lahore High Court relied on a few different reasons. One of the reasons was that one of the core purposes of the law is to protect wild animals. And so when you're considering what action the department is taking, that action has to be in consonance with what the law envisions. And since the law envisions protection of animals, certain deference has to be given to this decision of the department. The court also said that the use of electronic decoys is against the principle of sustainable hunting. It's also against fair chase principles, because using these devices give hunters an unfair advantage over the animal. But importantly, for our purposes, the court also relied on Cavan and kind of independently adopted the reasoning that Cavan had put forth, and said that, well, Cavan has affirmed that animals have legal rights, and when you infringe those rights, you're infringing human rights, human constitutional rights. And so those rights in Cavan were protected by anti-cruelty laws. In this case, are protected by the wildlife protection statutes. And so the Lahore High Court then reaffirmed that because animals are sentient, they can feel pain and joy, they have natural rights, and which are protected by law. And this includes, the right to life, but this is not a constitutional right to life. However, the constitutional right to life is infringed when the legal right to life of animals is infringed. And it is the duty of the state to ensure that none of these infringements happen. And in doing so, the court employed a species best interest standard, and basically gave a lot of weight to animals' right to life when weighed against the hunter's interest to hunt. And the last case from Pakistan that I'll talk about is this case, Sunita Gulzar versus the province of Punjab. A brief background to this case is that there's an increasing trend in Pakistan of keeping exotic wildlife, especially big cats, as pets. And this is enabled in the province of Punjab through Section 12 of the Wildlife Act, which allows one to possess a wild animal if you have a license. The agency, the wildlife department, has interpreted this to mean that if you have a license, you can keep a wild animal as a pet as well. And the petitioner in this case challenged the specific provision, saying that it's unconstitutional because of the principles laid down in Cavan. Of course, again, Cavan was not controlling, but it's one of the authorities that the petitioner relied on. And so this case hasn't been decided, it's still sub judice. However, in its admitting note, which is the point at which the court was deciding whether it even has jurisdiction over the matter, the Lahore High Court noted that after the Cavan decision, the contours of constitutional rights for non-human animals need to be further defined. What does this mean when we're making this link between human constitutional rights and animal legal rights? And interestingly, so the High Court gets its jurisdiction to issue certain writs and to hear certain cases under Article 199 of Pakistan's constitution, which says that any aggrieved party, when their rights are being violated, can approach the court for redressal. And the court says that it's interesting that the term used is aggrieved party and not person. And so what does that mean? Does that mean that if we're saying animals have rights, can they be an aggrieved party and come to court? Can they have standing to bring suit, in other words? And the court said that this is something we want to consider in this judgment. And so if once this case is decided, which it hasn't been yet, it could be an opportunity for a court in Pakistan to actively or affirmatively rule on the question of animal legal personhood. So far, the court constituted a committee to regulate big cat ownership. And the major problem in this case really is that the law is so ambiguous about whether you can actually keep wild animals as pets. So that was just briefly about Pakistan. Moving to India. So in India, the case that I think some of you might already be familiar with, in 2014, the Indian Supreme Court in Animal Welfare Board of India versus Nagaraja affirmed animals' legal rights. So this case challenged the practices of Jallikattu and bull cart racing in certain Indian states. These are sports involving bulls where participants try and hang on to bulls, or they try and remove flags from the horns of bulls. In this case, the court said that, firstly, again, details the ways animals suffer when they're being used in these sports and festivals. And then goes on to detail what statutory protections animals have under India's anti-cruelty laws, and recognizing that animals are sentient and they suffer emotionally and physically in these sports. The court said that animals have inherent rights. They should not be treated as a means to an end. And these statutes protect animal legal rights. So very similar to what the court in Kavan ruled, but Nagraja predated Kavan. So Kavan is actually modeled a lot after this judgment and also relies on this decision. And similar to Kavan, this case also drew a link between the constitutional human right to life and animals' legal rights protected by anti-cruelty statutes, and declared that these practices violate the federal anti-cruelty law in India. And so because the anti-cruelty legislation is federal and the legislation that allows for these practices to continue is state, there's a sort of a preemption issue and the federal law prevails. And so these practices were essentially outlawed. Nagraja did not speak to the question of animal personhood. However, in the relief section, the court did say that it expects Parliament to elevate the rights of animals to the status of constitutional rights. So it didn't really declare animals to be legal persons, but did affirm that they have legal rights that are linked to constitutional rights. And also, just as an aside, India does have really, so insofar as any country has good constitutional protections for animals, India has encouraging language in its constitution for animal protection. So after this decision, there were two decisions in 2018 and 19 in India. These are high court decisions that affirmed that animals are legal persons in those specific states. The first one is Narayan Dutt Bhatt versus the Union of India, in which the Uttarakhand High Court, in a case which related to the interstate transport of horses between Nepal and India, declared that the entire animal legal kingdom, including avian and aquatic species, are legal persons, and that all citizens of the state are persons in loco parentis for the welfare of animals. It's unclear what this decision means, in that, did it mean that animals can now bring suit on their own behalf? Did it mean that citizens can now bring suits on behalf of animals, which they were already able to do? And then the other case that did it was actually authored by this judgment was authored by the same judge, but in a different state, which was the state of Haryana, and concerned a prohibition of cow slaughter act criminal conviction, in which very similar reasoning, and the court declared that the entire animal legal kingdom are declared to be legal persons. And so in those states, at least, animals were legal persons as of 2018 and 2019. In the rest of India, they had legal rights according to the Nagraja decision. And just this May in 2023, the Supreme Court of India issued its decision in Animal Welfare Board of India versus Union of India. So what happened in this case was that the states the same states that used to practice Jallikattu and bull cart racing were obviously unhappy with the decision, because these practices, which the states do consider to be very important to their culture and heritage, were outlawed. And so they enacted anti-cruelty legislation, which kind of reinstated these practices, but added additional safeguards around them. So the laws basically regulated them a bit more strictly than they were previously regulated, and accounted a bit more for the welfare of the animals concerned. And so this case went back to the Supreme Court, because the petitioners in this case said that, well, these are just cosmetic changes, and what these states are trying to do is they're trying to circumvent the will of the Supreme Court by enacting this legislation that doesn't actually protect animals. And in examining these petitions, a larger bench of the Supreme Court, so the Nagraja case was decided by 2 judges, this one was decided by 5 Supreme Court judges, categorically denied, firstly, that animals are legal persons in India. So the court said that animals have natural rights, and that's what we said, and legal rights, and that's what we said in Nagraja. However, they don't have fundamental constitutional rights, and they certainly cannot bring suit by themselves before an Indian court. And while this may be possible, this is not a question for the court, it's a question for the legislature. So having said that, and having clarified that, the court then held that the new laws sufficiently address the animal protection deficiencies that Nagraja identified, because the idea was never to abolish use altogether. The idea was always to make sure that animals are not unnecessarily killed or they're not suffering unnecessarily. And in fact, the court said that we actually can't even decide if a certain use is necessary or unnecessary, which Nagraja actually had done, because in Nagraja, the court had said that we shouldn't even be using bulls for these as performing animals, because bulls are inherently draught animals and they're not meant to be performing animals, unlike horses. That was the reasoning of the Nagraja court, and the court here in Animal Welfare Board said that's not actually something for us to decide whether the use is necessary. We just need to look at if animals are being used, are they being subjected to unnecessary pain or suffering? And in this case, the court said, well, no, because firstly, if the state thinks that these sports are part of their culture and heritage, that's again for them to decide, not for us to interfere in. Organizing the sport is permissible, and the new laws are adequately minimizing the pain and suffering that's associated with the sport, which complies with the federal law that prohibits cruelty. And because the new laws don't violate any animal protection laws or other constitutional provisions in the Indian Constitution, partially because animals don't have any constitutional protections, the new laws are not contradictory to what we held in Nagraja and should be strictly enforced. And so just to conclude, a few parting thoughts, what are our takeaways from all of this? Well, firstly, what is the impact of this decision on the state decisions that declared animals to be persons within their own states? I think that because, again, it's a unified judicial system, those states, firstly, those judgments, their impact was always a bit unclear. However, insofar as they said that animals are legal persons, the Supreme Court of India has now categorically said they're not. So those decisions, to that extent at least, have probably been overturned. Also, animals are not legal persons capable of bringing suits in their own name in Pakistan and India, but so what, right? Does that mean that suits are not being filed to protect animals? And does that mean that courts are not protecting animals? That's not the case. So standing really isn't as big of an issue in at least this region as it is, for example, in the US. And the bar really is, or the standard really is, public interest. So does the issue affect public interest? Does it affect enough human fundamental rights? And if so, then courts are usually more often than not willing to hear the case. And so standing is a reason why courts just, maybe personhood doesn't matter as much in South Asia, maybe, as it would do in the US. Overall, the trend has been very positive, but with this recent Indian Supreme Court decision, and in Pakistan, we're now seeing that courts are exercising more restraint when it comes to animal protection cases. I think there's a slight dip or a regression. However, this is, again, very recent. So we still need to map out trajectory of future cases to see if courts are actively trying to restrain themselves when it comes to questions of animal protection. And in Pakistan, the issue has actually never gone up to the Supreme Court. So we don't know how it'll be handled there. And lastly, just the questions that we've always struggled with as animal lawyers, like, are courts the best places to decide questions of personhood, or is this something for the legislature to decide? And even if it is a question for the legislature to decide, will this be happening in South Asia anytime soon? My guess is no. The legislature is very, very slow in especially Pakistan. The anti-cruelty law hasn't even been updated since 1890. So it's very unlikely that that the legislature will be declaring animals to be legal persons, but we can hold out hope. So that's it from me. Thank you so much.
Thank you both for your wonderful presentations. And I can't help when I was sitting up here thinking that years ago, the three of us had a wildlife law class where we all sat next to each other. So it's really special to be up here with you both now. And so we'll turn to questions from the audience. If you have a question, please line up behind one of the two mics at the front of the room. And for those joining us virtually, you can submit questions via the Q&A icon at the bottom of your screen. We can start with an online question.
Thank you. Is there any statute of limitations on when you can sue a city government? And this person is referencing a city shelter that violated a 7-day hold to protect animals for adoption before euthanasia, a case or an incident that happened 8 years ago, but supposedly they are continuing to illegally kill dogs and cats?
I think that's a great question, and I think I could answer that better with some more information. So if you would like to email me, you should, but if anyone else up here has an answer to that, feel free to jump in. But yeah, I think I'd have to look at the law. Sorry, it depends.
So my question is, so after that HIPPO development in 2021, October, November, we saw at least one state, Idaho, introduce a bill sort of banning the extension of legal personage to the environment, to animals, to AI and the like. And I'm curious if you have seen other developments at the sort of legislative level. And so with respect to the US, but also, with these developments really taking root in South Asia and in South America, are you seeing legislatures sort of respond somewhat negatively to control what is effectively, creating more avenues for justice for animals?
That's a great question. I think the bill you brought up is the clearest example I have seen from the legislature, and I certainly haven't seen on the opposite side positive developments either. But I think there might be some more interesting developments outside of the US. So I'd love to hear what Hira and Diego have to say.
Yeah, I guess that at least in South America, we have seen more developments through jurisprudence, and it will be interesting to delve deeper on the reasons or why is this happening actually, because it's like a sociological maybe reasons that is conducting that jurisprudence is actually advancing animal rights, but at the same time, the most of the people in those countries are great meat eaters. There's a huge industry on meat. We have tried to advocate for new changes in legislation, but they're always leave apart. For example, in Chile, we are going through this constitutional process. In the first constitutional process, we had a couple of interesting articles that were recognizing animals as subject of rights, at least implicitly, because they had the right to not be mistreated. So if animals have at least some right, they would have been legal persons. We also supported through the Interspecies Justice Foundation this motion that tried to create a sort of constitutional protection action, especially for animals. But sadly, that motion was mixed with other more welfarist legislative initiatives. And at some point, it happened something that we weren't expected, that basically that project of constitution was widely rejected by the citizenship. And now we're in the second constitutional process, and we have nothing similar like an article protecting animals, not even recognizing sentience. That is something that it was like a huge avant-garde concept, but 20 years ago, maybe by now it's not it's important because it can help to maybe create some sort of policy framework when the state is trying to decide some plans or projects. But by now, maybe it's not the most important thing we can do. Well, I guess that in Argentina, in Ecuador, and even in Brazil, the jurisprudence is super strong. They're a huge model for us. And at this regarding Chile is just about making its first steps in this sort of regional trend of recognizing animals as legal persons. But well, a couple of years, no, in fact, last year, a civil court issued this really interesting decision where basically it recognized animals as part of the multi-species family. And in Chile, it's more difficult to do it in Argentina because we're way behind, but the decision was grounded on a property perspective. It was a little bit unconventional, but at the same time, it was a solution that it may work or it may keep working in a society like Chile. I'm not sure if you want to add something.
Yeah, I think the Nagraja case is a really good example of the legislature trying to undo something that the court actively declared or wanted. And in fact, I think in that case, in this recent decision or judgment, the petitioners actively tried to argue that these are very cosmetic changes, and these laws and these protections are never going to be enforced just because of the way the festivals are actually carried out, the amount of people involved, difficulties with enforcement. And the court said, well, just the fact that a law is difficult to enforce is not a reason to strike down the law as unconstitutional. And that's why the relief specifically said the laws have to be strictly enforced, because the court recognized that this was somewhat, I guess, a valid argument. But I do think that when courts make certain pronouncements that maybe people or legislatures are unhappy with, I think this is a good example of, at least in South Asia, where we've seen the legislature try to circumvent what the court wanted.
Hi, thank you so much for this wonderful discussion. My name is Ashley Nemeth, and I work at the Center for Human Rights at NYU Law. I wanted to get your take on whether you think rights of nature or right to a healthy environment is a way to further animal rights and legal personhood. At least in Latin America, we've been seeing a lot of really interesting and strong developments in rights of nature. For those unfamiliar, I want to flag the Los Cedros ruling out of Ecuador, which used the constitutional rights of nature to protect a really important forest. So I want to know whether you think it's a valuable tool to use to further animal rights and personhood.
Well, I guess that's an interesting question, because if we think about, for example, liberating an animal from his enclosure, maybe invoking the rights of nature may be a framework that it may work, but at the same time, I think personally that invoking or using environmental framework, at least regarding the evolution of legal personhood jurisprudence, it may not be the best idea, because look what happened with the Torres case, right? The court grounded its decision on the violation of the human rights to a healthy environment. Okay, it's not the same that the rights of nature, but sometimes when we use an environmental framework, we are like addressing animals as a species or as a part of a whole, that it may be good, like from an environmental perspective, but it may not be the best solution in order to advance or recognize rights for specific animals. But it will be interesting to carry out more research and to find innovative solutions in order to try to compatibilize like both environmental rights, the human rights to environment or a healthy environment, and at the same time, animal rights like per se.
I agree. I echo a lot of Diego's reservations with respect to rights of nature and using that framework. That said, both of the kind of seminal cases that I talked about in Pakistan, Kavan, and in India, Nagraja, both of them actually did rely on, so when they linked the constitutional right to life, that right to life has actually been interpreted in both jurisdictions to mean the right to a healthy environment. Because, I mean, India still has constitutional provisions that speak to environmental protection, Pakistan doesn't. So for Pakistan, all of the environmental protection jurisprudence is derived from the right to life. So the court was kind of building on that jurisprudence. So actually, I think it has been used successfully. And of course, I think we need to use whatever we can to protect animals, just because the tools we have can sometimes be very limited. So I would definitely not rule it out. It's very helpful.
And I can add to that quickly. I think that those laws have been successful internationally because, like you said, they're based on the constitutions in those countries, which are totally different from the one we have here. And so, although I think rights of nature laws are great because a lot of them specifically say, animals are persons, they're just mostly unenforceable. But it would be great if we could enforce one. I think we may have time for one quick question.
Hi, thank you so much for this panel. I was curious, reflecting upon what we learned this morning, what the development in this jurisprudence means for factory farming and for research labs, and if you feel as though this could be helpful in that regard.
Great question. I do see we're almost out of time, so I can say quickly that it would be great if these laws, at least in the US, could apply even to wild animals. So I think as everything is now, it will be very hard to enforce those laws to animals that are owned by others as well. And if anyone has a very quick thought, you can jump in, but.
Yes, I guess that in order to address industrial animal agriculture, maybe invoking the rights of nature may be a good solution, but it's like it has two sides, like a good side and a bad side. And I guess it's all about trying to find the best solution to the case you are trying to address or to solve, but at the same time to be conscious about all the consequences that that solution can have in the sort of evolution of the animal rights jurisprudence. I guess here in the United States, it's more difficult because the legal decisions, sorry, the judicial decisions are binding, but back there in South America, we have a civil law system that it may be a little bit easier to maybe obtain a solution that may work for a specific case, but that may be bad for other kind of cases or objectives, such as recognizing animals as legal persons.